Hello, everyone, and welcome. We've got quite a lot of attendees registered, so I'm just going to do a little bit of intro filler while we wait for everyone to join. Obviously, you've joined us today for our Christmas webinar called Mistletoe, Misconduct and Mitigation, Employment Law at Christmas and Beyond. Today, I, Alex Harper, Senior Solicitor in the Employment Team here at Harrington Carmichael, and joined by Joe Boxhall and Isabella Milnes-James. Sorry, Isabella. And collectively, we're just going to be taking you through some slides. I'm going to, as people are joining, just sort of move across to our overview slide just to give you a bit of a flavour of what we're covering. So as was explained in the invite, we're going to be looking at the Worker Protection Act. Obviously, we're 1 year on. I'm sure many of you remember this time last year hastily putting together sexual harassment policies in anticipation of the new law coming into force. So we're just going to have a quick look back at what happened across the first year of it being in force. Then we're going to look at, because we can't avoid it this time of year, Christmas parties and kind of festive pitfalls, the common things that we see arising this time of year and in early January. And then as a final note, so we're not ending on a tinge of sadness before we all go to our Christmas parties, looking ahead at 2026, broadly, what are we anticipating? That won't be the focus on this session. We could and do very often whole sessions on what to look for in the new year, especially with the Employment Rights Bill coming into force. But we'll just offer a quick recap and a sort of quick overview of where we are now with the ERB and what we're expecting going forward. That's broadly kind of the overview. I just want to say, as we're still letting people in, I don't want to move forward so people miss too much, but participation through this session is absolutely encouraged. Please feel free to raise your hand or pop questions in the chat. We will have a few slides where we're going to invite participation, so we're going to take you through a case study on sexual harassment, as well as having a brief sort of discussion about kind of Christmas parties and anyone's experiences of those. If you would like to participate, we would encourage you to share those stories. I will just remind you now at the beginning that this session is recorded and then shared with all attendees and registered attendees. So if you are going to tell us about a horror story in a Christmas party gone wrong sort of scenario, then just bear in mind that you might want to change some names if you're concerned about confidentiality. So I think, given that we're now nearly 5 minutes in, we'll move on to the next slide and start with a recap of the Worker Protection Act.
Thanks, Alex. So I'll be taking this slide to give us a recap of the new legislation that came into effect October last year. So as Alex said, I'm sure many of us were quite frantically scrambling around for the prevention of sexual harassment policies as a result of this new piece of legislation. So what the Worker Protection Act did was introduce significant changes on employers. They had to take proactive steps to prevent sexual harassment in the workplace, so taking reasonable steps. As is nearly always the case in law, there's no definition legally of what is reasonable, which is always very helpful to us. So what we do is we look at the employer's size, the resources available to it, and other contextual circumstances, such as what sector it functions in which to determine whether such step is reasonable. An employer typically will have taken reasonable steps if there are no further steps that they could have reasonably been expected to take, and that's quite a mouthful in itself. So, is there another way that an employer could have achieved that prevention? Is there another mechanism that we could have used to stop or prevent that sexual harassment? It's important to note that the new Worker Protection Act and the duty to take reasonable steps to prevent sexual harassment is not a claim in itself. So it is used by an employee where a successful complaint of harassment has been upheld. And then we look to see if the employer has maintained that duty accordingly. Now, if it is found to have been breached, this new duty, it can uplift the composite pot of compensation by up to 25%, which is quite a hefty burden on employers, particularly because discrimination claims are uncapped in terms of compensation. We do base them on what we call vento bands, which I'm sure you've all heard of, which increase every April. So we have a lower band of 1,200 to 12,100, a middle band of 12,100 to 36,400, and then a higher band of 36,400 to 60,700. And in really serious cases, we can even exceed that. So without further ado, I want to now pass on to Isabella, who is very kindly going to take us through the legal definition of sexual harassment.
So we all have an understanding of what might constitute sexual harassment, but the statute defines it as unwanted conduct of a sexual nature that has the purpose or effect of either violating a person's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment. And as I'm sure everyone is aware, sexual harassment is not gender specific. Anybody can be sexually harassed, and a person can be sexually harassed by a person of the same gender or different. On to the next slide, please.
Yeah, so there's a really important distinction there, because I think a lot of people get confused with harassment, sexual harassment, and harassment on the grounds of sex, which legally are actually two very different things. So to help that, we're going to talk through this case study that I've appeared on the screen, and we're actually going to launch a poll to get you guys to participate and tell us what you think. So Sophie works as a receptionist at a large hotel. James is the hotel's assistant general manager and often makes inappropriate comments about her appearance. For example, he might say things like, "You look stunning in that uniform," or say, "You should wear skirts rather than trousers as they suit you better." These comments make Sophie feel uncomfortable, but she tries to brush them off and carry on. However, at a staff party, possibly the Christmas party, James' behaviour escalates. And after a few drinks, he puts his arm around her and says, "If you play your cards right, you could get promoted here quickly." Sophie feels humiliated, particularly as this happens in front of her colleagues. Since then, she's been avoiding staff events, dreading any situation where James might be present. And I think Joe is going to launch a poll now, so we can gather.
Working its magic. There we go.
Amazing. On whether you think this behaviour satisfies the definition that Isabella's just taken you through of sexual harassment. And as soon as those results come through, we will share those. So I think I don't want to spoil the content of the slides as we go through, but we can unpack quite a few things in here. I don't know, Joe, if you can see the results as they come through.
So far, we've had 40 responses, and all of them are coming back with yes.
Excellent. Okay, well, I'm going to make it easy for the last couple of 6 of you who haven't yet voted, and tell you that you're absolutely right. This behaviour would easily meet the definition of sexual harassment. Even the comments in the first paragraph on their own are sufficient to meet the definition, because we're not just talking about physical contact, which is an important distinction to make. So it's not as if the first paragraph would have been okay and then the second paragraph is where it went over the line. I think it's really important to understand that sexual harassment can come in the form of comments rather than purely kind of physical actions. I think what makes sense now is to look at what does it mean in practice, and I'll pass over to Joe to take you through that.
So we're going to be breaking down that legal definition into more practical terms so we can actually understand it. as Alex said, it doesn't have to be physical touch to constitute sexual harassment and fit within that definition. It also doesn't have to be in person. So if I was to make a comment over social media or Teams, for example, or email, that is in the course of my employment, and that can be captured by that definition. So when we look at unwanted conduct, that typically means unwelcome or uninvited, unsolicited, if you were. It does need to be conduct of a sexual nature, but again, it doesn't need to be physical. So like comments can be inclusive of that. We also need to be thinking about the perception of the individual receiving that comment or others around them, because looking at what Isabella has said, it is looking at the purpose or effect of what that comment or conduct did to that person. It does not matter if it was dressed up as banter or a bit of a joke. It is the effect that is what is important. We also need to consider things like aggravating factors, such as seniority within the company, to see actually contextually, is there a power dynamic here that means that that person has been particularly affected? For example, in that case study we looked at, that was a senior manager saying you could be promoted in the business if they submitted to sexual conduct. So that would easily be an aggravating factor to be considered. As Alex already said, an individual can also be harassed by someone of the same or a different sex, so it doesn't matter. It's regardless, and it also can be overheard. You don't have to be the individual who received that comment either. So I'm going to pass back now to Isabella, who's going to take us through what we need to be doing in terms of reasonable steps to prevent that sexual harassment.
So as Joe explained earlier, we're not given a definition of reasonable steps, but around the time that the law came into effect, the Equality and Human Rights Commission issued guidance in the form of 8 steps to suggest what employers might do in trying to perform this duty. So the ECHR have also confirmed that this isn't, strict guidance that everyone has to do all of it, but it should help employers when trying to comply with their duty. So the suggested steps are, as I'm sure you all have already, but having a standalone sexual harassment policy, not one that's just lumped in with the rest of the handbook, but a standalone one in itself. Conducting surveys and exit interviews, which might help uncover things that you didn't realise were going on in the business. Undertaking a risk assessment to identify risks. So as Joe was just speaking about that power imbalance, that might be something that you pull out in your risk assessment, and then you think about ways you might caveat that. You should also establish clear and confidential reporting channels. This might be an anonymous tip line. You should provide tailored training to different levels of the business. So there might be different training for all staff or managers or the SDLT. You should also take prompt action when complaints are raised and respect the confidentiality of the parties when conducting the investigation process. You should also address any third-party harassment, which Alex will be talking more about later, but this would include the reporting mechanisms that we just spoke about. You should also be regularly evaluating the effectiveness of the steps that you've put in place and to determine whether or not they have been effective in preventing sexual harassment. Joe commented on this earlier, but the number of steps that should be taken and which of the above that we've just spoken about will depend on the size of the organisation. For larger organisations, the expectation will be higher. But as a minimum, we would suggest the standalone policy, the risk assessment, and then the company-specific training. But it's not a tick box exercise. Employers are under a constant duty, and they should be proactive, not reactive. On to the next slide, please.
I think that's a really good point. Just before I go on to that next slide, I think it's worth saying at this stage that now is the time to be doing that review process. So one of these steps there is, monitoring how the measures you've taken are working. It's been a year now since the Worker Protection Act came into force. So you couldn't really get a better time to start going, hang on, do we need to look at this? Do we need to look at what we did? Did we do enough? Are we satisfied that what we've done has worked? Have there been cases that we need to learn lessons from? So that's just a little suggestion from me there as you know, before we move on to third party harassment, that actually now is a really good time, as you've had a year probably since your policy, maybe slightly more, came into effect, to look at it and really dig into whether you need to be updating that suite of documents with any kind of lessons learned from the first year. Looking at third-party harassment, this is slightly different. So the Worker Protection Act covers employee, you know, well, it covers everyone, but there's a focus, particularly in policies, on kind of the actions that you can be liable for as an employer. Third-party harassment is much broader than just employees. And it also critically is much broader than just sexual harassment. So the first kind of point there, protection question mark, it means this covers kind of third-party harassment, covers all kinds of harassment, not just sexual harassment. And this is why when you guys have all been out and about, you will see signs in workplaces that are kind of public serving kind of or public facing venues, for example, on trains or in restaurants and bars or in shops, that say we do not tolerate any kind of harassment against our staff. This is the reason that those signs are up, you know, this kind of liability for third-party harassment that employers are taking on. And part of a lot of employers, particularly in a kind of public-facing setting, part of their strategy for, you know, trying to reduce their risk space there is having signage such as that, covering off potential for harassment. But what is a third party? What does that actually apply to? So it's, as you'd expect, quite a far-reaching definition. So we'll cover clients, customers, visitors to your workplace, as well as members of the public. So it's really as wide as you can anticipate it being. There is no hiding from third-party harassment, and you need to be taking steps similar to those that you're probably taking internally with your employees to ensure that you're protecting your employees from harassment in the workplace. And that kind of brings me on to employer liability, which is slightly different currently for the third-party harassment than it is under the Worker Protection Act. So the Worker Protection Act, obviously, at the moment, has the obligation to take reasonable steps to prevent sexual harassment. That's not the case with third-party harassment. Employers will be liable for acts of third-party harassment unless they can show that they have taken all reasonable steps to prevent it. Now, what that looks like in practice is if you have a case, and again, as Joe says, it's not likely to be a standalone case, but possibly a claim brought alongside something else. If you have a case in the tribunal and third-party harassment is one of the issues in that claim, if a tribunal can think of one single thing that you haven't done to prevent reasonable to prevent sexual harassment or any kind of harassment in your workplace, then you will not succeed in saying you're not liable because you've taken all reasonable steps. So you could take all 8 steps that the EHRC recommends. You could take 10 steps. You could take 12 steps to prevent sexual harassment in the workplace by third parties. If the tribunal judge on the day can think of one more thing that you didn't do, you won't successfully meet that test, and you won't successfully defend the case that you're not liable, and the actions of the individual, let's say, are where liability sits. It's a high bar. It's a bit scary, and Joe will touch on this later as we look at how the Worker Protection Act might change in the near future. That also kind of leads me into the government commitment. So essentially, what the government has said is they are committed to creating and maintaining workplaces that are free from all kinds of harassment. And this is where the Worker Protection Act and how that might change with the new Labour government really comes into play. It's a strong commitment, and it's one of the key areas it impacts is that kind of idea of what reasonable steps are and how many you should be taking. So I think that probably summarises where we've all been for the last year going through the Worker Protection Act. So what I'll do now is hand over so we can start talking about Christmas parties.
It's something exciting, I hope, and now not terrifying to all of you watching. It is very much a time for celebration, but it is also about being mindful that Christmas parties are a prime time for potential sexual harassment to occur. There's alcohol, we're off site typically, we are enjoying ourselves with our friends. So there are enhanced risks, but we'll be taking reasonable steps to prevent those risks. If we go to the next slide, I'm going to take you through some considerations that you should have in your mind just before the Christmas party is coming up. So an employer will be responsible for the actions of all employees carried out in the course of their employment. That's a principle of vicarious liability. So even though the employer has been good as gold, if there has been an employee who's been a little bit underhand, the company will be liable for their actions through this principle. So we are focusing on the fact it is still in employment and the higher risk. And so we're managing expectations with our employees. I would suggest that leadership set an example and say this is the level of tolerance we would expect, and we don't obviously tolerate sexual harassment in any venue, regardless if it's at work or on off-site premises either. Common issues that typically arise after Christmas parties and in the new year are discrimination, sexual harassment on the grounds of another protected characteristic, such as, for example, disability. If there was no platform for somebody who wouldn't be able to walk up to that part of the party, things like that we just need to be mindful of. Now, generally, these are dealt with informally, raised informally, but they can quickly escalate to full grievances. So it's about acknowledging that risk at the beginning and doing what we can to manage that risk at that time to prevent that from happening. So I'm now going to pass to Isabella, who will go through how employers can mitigate those risks even further.
So thinking about inclusion first, when picking the location for the Christmas party, think about the location itself and think about timings as well. So the venue that you choose to host your party in, it should reinforce your workplace standards. So perhaps a restaurant or a hotel function room. Equally, if you think about some venues, they might be quite a bit dark or have some secluded areas, so perhaps it's better to have a more open plan venue where there are well-lit areas as well. In relation to timings, being mindful of those who have dependents and providing as much information as possible before the event that they can plan their responsibilities and still attend. So social media, back to what Joe was just speaking out about in the course of employment. As Joe said, employers can be vicariously liable for the acts of their employees. So this could include posts on social media relating to the work Christmas party. So how to mitigate that risk. Firstly, making sure your social media policies are up to date and cover situations like this, and perhaps putting them on your intranet again ahead of the Christmas party to remind people of the expectations on them. Alcohol, they do tend to be quite alcohol-fueled events, but there are ways that we can mitigate that risk to us. So perhaps rather than having an open bar or loads of cash behind the bar, putting a limit on that. So perhaps everyone can have one drink before dinner, and then with dinner, maybe half a bottle per person, but not unlimited access to alcohol. Also in that, considering people who don't drink, are there alcohol-free options? Are you aware of those people so that they have that available to them on their tables? Thinking about the journey home, how people are going to get home. So with the location of the venue, again, are there train stations nearby? Are there taxi services you can make people aware of so that there's no risk of drink driving or anything like that? On the drink driving point, perhaps you might have a later start to the next day so that people have longer in bed, longer to recover. Don't feel pressured to drive when they perhaps shouldn't be. And again, Joe mentioned top-down approaches. I think if the senior team are behaving responsibly with alcohol, hopefully that should be a reflection to the rest of the company on how they should be behaving too. And then finally, with policies and management, again, having the robust procedures to make sure that and making sure that your employees are reminded of these policies prior to the party. So as I said before, maybe a post on the intranet just to remind people of key policies and where to find them, and making sure that your line managers are prepared as well, so they can remind the employees of the standards expected of them, and again can point them towards the policies as well. So I think I'm passing back to Joe. Oh no, Alex, I think now.
Yeah, so this is kind of participation slide. We couldn't forgive the Christmas pun. We couldn't resist. So you'll be heard. Tell us your stories. Helpfully, while people may be typing away with some stories or questions about kind of Christmas parties. We've had a question in the chat, so I'll read that out and then go through the answer. So the question is a good one. What about perceived discrimination from people who choose not to attend the Christmas party and feel that is frowned upon? Or what about the people who feel pressured to attend but would prefer not to attend? Now, Isabella and Joe, feel free to jump in. I'm going to start with saying that obviously people may have good reasons for not attending a Christmas party. So there should be very clear messaging from kind of the top of the business that you shouldn't be pressuring people to come. And you shouldn't certainly be giving the impression that it's frowned upon if you don't come. That said, it does sometimes happen. In and of itself, that won't be necessarily discrimination, because not wanting to go to a Christmas party isn't a protected characteristic under the Equality Act. However, there may be protected characteristics that underlie the reason that they don't want to attend. So, for example, someone who's a non-practicing Christian, someone who's not Christian, and doesn't practice the kind of holiday of Christmas may not want to come to a Christmas party. Someone whose religion prevents them, precludes them from drinking may also not want to come to a Christmas party. Now, if they feel like that's frowned upon or and they're being pressured to attend, that is a real risk space from a discrimination perspective, because if essentially you're treating them less favorably because of a protected characteristic they hold. So my advice for that is, look, it's not inherently discriminatory to sort of be saying it's nice for everyone to come and have a chance to get together and celebrate the end of the year. But you need to be very clear with messaging from the top down that there is no pressure to attend and people are free not to attend as they choose, and people shouldn't be asking questions about or pushing people to come if they've said no. It's kind of like the principle of anything in the workplace, really. It's that just be respectful, mindful that other people may not want to come to a Christmas party, and actually that's okay. Joe, Isabella, do you think I've missed anything there?
No, I think you've summed it up perfectly. The only other examples I would think of in terms of a protected characteristic are disability, for example. So if somebody has an illness that prevents them from going out later in the evening because they need to rest, we need to be thinking about that. And then Isabella rightly pointed out that perhaps people have childcare that they need to think about as well. So that's what we're sort of looking for. It's perhaps not just a frowned upon if you don't attend, but why are they not attending? Is that enough to then trigger that less favourable treatment and that discrimination criteria at that point? Yeah,
absolutely. And well, so far no one's come up with any kind of Christmas party questions or stories, which is disappointing. Come on, guys, participate in this session. We need to know you're actually there. I can tell you one of the kind of worst ones that I've had, which didn't transpire until January, when one of my clients, a HR director, came back from their Christmas holiday to a chunky grievance that had landed on their desk. This didn't actually involve it wasn't a kind of entire firm Christmas party, but was a team event where Secret Santa had been done and organized by an individual, like a separate team at a separate team event. Now, Secret Santa is the bane of my life. as an employment lawyer, I would not encourage people to arrange Secret Santa or to have very clear parameters if you do. I am not the fun police, but this case has ruined it forever for me, because someone in their infinite wisdom thought it would be appropriate and hilarious to give one of their colleagues edible underwear at their team Christmas party. So, of course, that was a disaster waiting to happen, and my poor client got back from their Christmas holiday to have a grievance land on their desk to basically complain, quite rightly, that that wasn't an appropriate gift to get. It was humiliating to unwrap it in front of the whole team. And although it was a kind of an anonymous Secret Santa, the colleague in question had a very good idea of who had sent the present, and had just generally kind of raised a grievance about other kind of behaviours that they had exhibited that were, you know, making her uncomfortable. This was a case of the person in question, the recipient of the edible underwear, was a woman, and the alleged kind of gift giver was a man. So this rang, quite rightly, a number of alarm bells for my client. This was pre-Worker Protection Act, so that wasn't a concern at that stage. But, you know, the same types of concern that would still apply now applied then. So very concerned in terms of sex discrimination, so kind of and particularly harassment on the grounds of sex, but also sexual harassment more broadly. So just to give you guys an idea of what happened in practice, just to take this through, they suspended the individual in question, started a grievance investigation, investigated with the recipient of the gift, the alleged gift giver, and then the witnesses within the team, and then followed the usual process that you would normally do. So grievance outcome, which, as you can imagine, upheld that it wasn't appropriate conduct, made a number of recommendations in terms of how to resolve it, and then separately started a disciplinary process with the gift giver, who had, as part of the grievance, confessed that it was them. In the usual way, he sort of then relied on the idea that it was just a joke, that it was banter, that it wasn't, you know, intended to be inflammatory, or and it wasn't intended to upset her. Of course, that doesn't matter, as you guys will all know. Doesn't matter what the intention behind an action like that is. All that matters is how it is received. So that went through a disciplinary successfully. In the end, in the end, what happened was, as this was pre-Sexual Worker Protection Act, I think it was a final written warning rather than a gross misconduct termination offence, on the basis that the individual apologised and went through training and appropriate kind of remedial action to kind of demonstrate their contrition to the satisfaction of the person who received the gift. So it resolved. It resolved as well as any of these situations it can, but still, it's forever put me off Secret Santa at Christmas parties. I don't know if Joe or Isabella have anything they want to raise. Otherwise, we can move on and look at what's coming up in the new year.
The only thing I can suggest is if we have some interaction to see how many people have still got to have their Christmas parties. So if we could do a thumbs up, perhaps, to say that you've got one coming up, and whether there is anything in the content of these slides even, that we have helped you with. So any preparation that you haven't already thought about, whether that could be helpful to you. Good, because see lots of nice little thumbs up.
Lots of thumbs up.
Which is really good, really encouraging. I as well think, is there a risk that we haven't already thought of that now you are now thinking of? Perhaps a third party, where the venue is, anything like that as well. Yeah,
Everyone's feeling very shy, Jo.
They
Everyone's
are
feeling very
feeling
shy.
very shy. We've scared them, Alex. That's why.
We won't read out your names, guys.
Mine's happening right now, and I'm not there.
Oh no, Alice. Well, I've just
Hmm.
said her first name, but we won't read out your last name.
This is
We've got a
great, thank you.
recommendation here for an email to be sent out to people attending a party. Is there any sort of template email we might be able to recommend? I think it's fairly, I mean, we don't have a template as such, but there's certainly standard wording that we send out in terms of making sure you're not the fun police. So you're just saying, you know, have a nice time. We're not saying don't have a nice time, but we're saying be mindful of the policies. So that is something that we can put together. So yeah, we can absolutely help with that. It's kind of finding that balance of reminding people that it's okay to have a nice time, but also that, you know, the party itself will be a work event. Any kind of after party is also going to be a work event, and thinking ahead in terms of these are the policies, and then I would just, as an aside, kind of sending an all staff email about Christmas parties was always a good idea. But then you might have a slightly different one that you send to line managers, for example, where you say, look, this is what you need to be mindful of, and we would just ask that as line managers of the company, you take a view, and you know, we're not saying you have to be the fun police either, but you know, if you see something, you know, please just bear in mind your seniority in the business, and you know, try and act according, you know, in accordance with that seniority.
Yeah.
What about you guys, Isabella, Jo?
I was going to say, calling out that behaviour if you see it as well. So as managers, you are responsible for the culture of the business, and the behaviour you walk past is the behaviour you tolerate. So it doesn't have to be aggressive by any means, but perhaps saying, well, that comment wasn't appropriate. We all know what sexual harassment feels and looks like. It doesn't feel comfortable. That's why it's unwanted. So if we're recognising that, it's about nipping it in the bud. Of course, we're adults. We're all allowed to have fun, but it's about managing that fun and expectations on your employees and your colleagues. I've just seen comments from Julie that she no longer has Christmas parties because of all these issues. We don't want to discourage that, because it's a celebration at the end of the day, and we've all worked very hard this year. It's just being mindful about what risks there might be and what we can do to prevent those risks from happening. I can see Tara has also said that they're providing alcohol unlimited. Again, that's fine, we are adults, but it's about managing expectations, thinking, although that alcohol is unlimited, let's be sensible about it as well. Making sure that everybody knows how they're getting home, as Isabella said, making sure that senior management are setting the right example, calling out any behaviour that doesn't look right, and just, again, enjoying ourselves, making ourselves all feel safe, because we all deserve to feel safe at work and in the course of our employment. I can also see Caroline's said that hers is happening next week from 2 till 6. I think that's a great time as well. I wish that ours was 2 till 6 personally, but that's a really great example of an adjustment you might have made. And if there was any perceived risks, what you're changing about it. We don't all have to always go to a hotel in the evening with alcohol. Perhaps we can have a nice lunch all together to celebrate you know, what we've done throughout the year.
I think that's a really good point, Jo. I think a lot of employers are looking at more like activity events now as well. May not be applicable if you're doing a huge company-wide event, but certainly team events where, you know, you've got people in the team who don't drink, for example, doing something that's more activity based. I think the popular ones at the moment I keep seeing are axe throwing, although that seems like a whole other potential risk.
That comes with its own risks in itself, doesn't it?
Yeah, like axe throwing. I think like there are, you know, like I'm trying to think of all the things I've been seeing recently. Like you know, going to Flight Club and doing the darts kind of experience, and it just means someone who doesn't drink has got something that's not, alcohol's not the focus of that if it's an activity based event. So someone who doesn't drink, for example, might not feel so pressured in an environment where there's something else to focus on. Yeah, so Tara said they're doing axe throwing. Tara, to be clear, I'm not saying there's a legal risk there. I just meant axes going awry seemed like I
like the sound of Alice's one, the charity scavenger hunt and cocktails and dinner. That sounds like a wonderful celebration.
That sounds great. Yeah. Oh, well, I'm glad we've ended this on a nice note, and we haven't ended on horror stories, because to be honest, they are still the exception. I have to say, and I think Joe and Isabella probably say the same. It's not like I come in every January after our office opens again after Christmas, and suddenly I've got 10 grievances on my desk from different clients who've had disasters. It's still very much the exception. So, we're just saying, there are steps you can take to mitigate the worst case scenario. It's not a case that, Christmas parties are all doomed. All right, well, we'll move on then. So we can look ahead. What's coming up in 2026?
So not to scare you, but the duty is going to be increasing. So we're going from reasonable steps to all reasonable steps, which will likely mean employers need to do absolutely everything possible to prevent sexual harassment. There will be a public consultation on what measures could be considered reasonable. They'll probably build on what we've already seen from the Equality and Human Rights Commission, but we have a list. It will be non-exhaustive. So it is about making sure we are doing absolutely everything we can as employers to make sure that sexual harassment does not occur during the course of our employment. Again, it's going to depend on the employer's size, its resources, its industry, so contextual circumstances will very much be taken into account as well. You're already doing a lot of these things as well. So again, no panicking, but risk assessments, policies, training, all things you're already doing. So don't panic too much at this stage. It will be going to all reasonable steps next year, but we will be prepared for such when it arises. So whistleblowing protections. At the moment, arguably, you could make a sexual harassment disclosure, and that would be a disclosure of a breach of legal obligation. So that's the information it tends to show. But next year, we will have protection in place for its own separate category, or specifically for whistleblowing. So I can make a report of sexual harassment in its own independent category, and I'll be protected from detrimental treatment or dismissal. It's also going to be extended to volunteers, which is slightly bigger. So we're extending that whistleblowing protection even further to make sure it is very clear that if we need to blow the whistle about sexual harassment, we can do so and we are protected by all means. NDAs, so non-disclosure agreements, settlement agreements, for example, or other commercial agreements that contain confidentiality clauses will be void if they contain clauses that prevent somebody from speaking out about harassment or discrimination. That's not to say it's a blanket ban. They can still be used to protect commercially sensitive information. And for example, if a victim of sexual harassment wants their information anonymised and doesn't want their information to be made public, then that might be an ability to change as well. So there is going to be a crackdown on these gagging clauses, as we call them, and the use of settlement agreements, particularly for harassment, sexual harassment and discrimination, but they still can be used in limited circumstances as well. It will also include disclosures made by workers about harassment or discrimination their colleagues have experienced, so it doesn't necessarily need to be the victim either. Again, like we said, we know that certain agreements will still be permitted in certain confidentiality obligations, and that will be specified in future regulations. Now, Alex has already touched on this, but I just wanted to speak about third-party harassment as well. So that will be extended to cover all relevant protected characteristics, and not just sexual harassment, but any protected characteristic. So it will prohibit employers from permitting third parties to harass employees during the course of their employment. The employers will be liable if both the conditions are met, i.e. the third party harasses the employee in the course of their employment, and the employer failed to take all reasonable steps to prevent that harassment. So the bar is going to be higher, but a tribunal recognises that an employer has less control over those third parties. So we're again doing everything we can to try and prevent it. and meeting that duty as much as we possibly can. So we've got a lot coming up in the new year, as I'm sure you're all readily watching what's been going on in the House of Commons and the House of Lords, and the ping pong that we're currently experiencing. Alex is now going to talk about the other things that will be changing in 2026.
The other thing so far, because we don't even since we did the slides, this has changed. So SSP is quite an easy one, and I don't think this will be contentious for many employers. So basically we're just looking at SSP provision being payable from day one, rather than having to wait for a period of service. Just make from day one of sickness, I should say, not for a period of service. It's just going to make it easier to administer SSP. In fact, a lot of you will probably have policies where you pay sickness absence over SSP anyway, so it's probably not going to detrimentally impact calculations. There are some sectors where this disproportionately impacts people, where you get people with short-term absences, and you may want to look at kind of how you do your self-certification period and whether you decide to shorten that and how that works. So it's thinking about practical things rather than this being a really big, scary change. It's not new, it's just being brought forward in terms of when you apply it. So that's how I would recommend thinking about SSP and not necessarily worrying too much about that one. Obviously, you have to comply, but I think if anything, this is probably going to make it clearer and easier to apply than the rules that were in place before. Collective consultation is a big one, especially for larger employers. So at the moment, many of you will know that if you're proposing redundancies at one establishment and you're proposing 20 or more of them, you enter into the world of collective consultation. They are now looking at changing the approach to collective consultation and removing that kind of rules about it. So there were rumours at the beginning that they were going to get rid of the establishment principle altogether, and instead of looking at whether or not you're making 20 plus redundancies in one establishment, they were going to apply it to the whole organisation. Cue large-scale panic, I think, from everyone. So I think during the consultation period that came out. So they've kept the 20 plus redundancies proposed at one establishment, triggering the collective consultation rules. However, they're also now, and we're still waiting to hear what the final word on this will be, but they've also now said there will be another threshold. And I think the last I heard, and Joe and Isabella, feel free to let me know if you've heard different since. The last I heard was this other threshold was going to likely be a percentage of your total workforce. So it will either be you're making 20 plus people redundant potentially at one establishment, and that triggers collective consultation at that establishment, or you're proposing to make more than, let's say, 10% of your workforce redundant potentially, and that will trigger the threshold for collective consultation. Again, this is all subject to change, but the last I heard was that they would still keep the establishment principle. So let's say you're a workforce with 10 different offices across the country, and you're looking at making 20 people redundant across the country, but not all in the same place. You're not likely to trigger collective consultation in every single establishment because you've separated, your redundancies aren't all impacting the same place. If you're, let's say, let's say you're doing 30 redundancies and 20 of them are all in one place, then that will trigger the collective consultation requirement, but it will be limited to collectively consulting in that location. You won't have to collectively consult with all of your employees. I think they've pared back what they'd originally proposed on consultation because they realised it was just unworkable for large employers. Or at least that's what I'm hoping they realised. I mean, who knows what the thought process is for some of these things. But I think essentially there was an acknowledgement that what would end up happening is employers with large workforces would just constantly be in consultation with their workforce, and that just wasn't going to work. The other big one that you will all have seen, especially given the recent changes, is unfair dismissal. So when we wrote the slide, we were all just happily looking at the fact that it wasn't going to be day one anymore, and we were all going to get 6 months. Now, of course, they've added in the new unexpected addition, which the House of Lords has just rejected, of removing the cap for unfair dismissal claims. So obviously, we have the statutory cap in place, which I think at last count was around 112,000. I'm looking at Joe and Isabella to correct me.
118.
118. That's 6,000 out. Or 1 year's salary, whichever was the lower. So you could claim in an unfair dismissal claim for either 118,000 or 1 year's salary if that was lower than 118,000. Now they are proposing, although it has just been rejected, that that cap will go. Initially, when they announced it, there was a thought that the statutory cap might stay in place, so the 118 cap would stay, but the lower threshold of a year's earnings would go. In the latest iteration, it was gone entirely, so unfair dismissal claims were uncapped in the same way that they were for discrimination and whistleblowing and other claims that don't have caps on compensation. So TBC, we'll see how this shakes out. Not entirely sure what that's going to look like in practice, although I did think, when they first announced removing the cap, initially I was thinking, gosh, this is going to increase the workload for so many clients in terms of spurious claims. But actually, in my experience, it's quite rare these days that anyone just brings an unfair dismissal claim anyway. So, most people, if they're trying their luck with an employment tribunal claim, will tack on some kind of discrimination element to unlock that kind of uncapped potential. So I don't know whether day-to-day removing that cap is actually going to have the impact that they think it is. Interestingly, the only group that I thought would possibly benefit from removing the unfair dismissal cap is people in that kind of like 50 to 60 age bracket, where it's difficult to establish age discrimination if they're kind of being moved on from employment, let's say, but also they don't have any other kind of any other kind of protected characteristic to rely on, and they're in that phase of life where I think most people would acknowledge it's just quite difficult to find a role. If you're looking for a new role when you're in that age bracket, it's quite difficult. It can take quite a long time to find a new role. If you remove the cap for unfair dismissal, and they're bringing loss of earnings claims, which can exceed now 1 year's salary, I can see a scenario where a 58-year-old, 59-year-old, or a 63-year-old, or even an older individual finds it very difficult, if not impossible, to find another job. So a loss of earnings claim, even on a pure unfair dismissal claim, could feasibly be someone from that age to their retirement age. And that was my practical thoughts. I'd be interested if anyone else in the chat, or if Isabella and Joe had any thoughts about it. When I thought it through, that was really where my thought process ended in terms of the kind of what practically removing the cap would do for unfair dismissal. Before I go on to fire and rehire as well, just thinking about that 6-month qualifying period, practically what that means is you're going to probably, a lot of you are already doing what you need to be doing anyway, but just backing it up a bit more in the new year when and if this comes into force. So 6-month qualifying period, that's going to sound very familiar to a lot of you guys. It's going to sound like probation, because effectively that's what it is. Most of you, I imagine, have some kind of formal process around probation. Most of you, I'd imagine, have line managers who don't really follow it. That's going to be the critical point, I think, when and if a 6-month qualifying period for unfair dismissal rights come into play. We're going to need to be taking the 6-month period, which is typically probation, exceptionally seriously, obviously we're going to need to be looking at performance. We're going to be needing our crystal balls and trying to figure out into the future whether or not this employee is meeting the standards we need them to meet, and we're going to need to do it in 6 months rather than 1 year and 51 weeks. So I think that for me is the biggest change. I think a lot of you will have policies in place around probation anyway. It's just going to be really managing line manager expectations and saying you don't have the time that you used to make an assessment on someone's performance. I mean, at least now we're not trying to do this, potentially assuming this goes through, we're not now in a world where we're having to do this before we've even employed someone. So we will have the benefit of time during that 6-month period of assessing someone and whether they work within the business, but it's still not a lot of time. So something to be really mindful of as and when it comes in. And then just quickly before I open up the floor for questions, just thinking about restrictions to fire and rehire. Obviously, there's been a lot of press about this. The government, it's one of those things that actually I think happens a lot more rarely than people think. And so it was very popular to, especially after, Fairies had a bit of a debacle in the press, which for those of you who followed it actually wasn't a fire and rehire situation at all. It seemed to become this buzzword within the government, like we're going to change fire and rehire, we're going to change, we're going to make it illegal, we're not going to let anyone do it. They have put restrictions in place and there is more guidance. There was already quite onerous guidance around what you had to do for a fire and rehire process anyway. But obviously the critical piece for us is the doubling of the collective redundancy protective award. So that's just something to be mindful of, because that's a fairly binary award. You either get it or you don't. So we just need to be mindful that is going up. And the financial cost of that, particularly if you're doing large scale or even just 20, but a protective award as it is substantial. And if you're doing 20 employees, to do that 20 times makes it even more so. So just something to bear in mind. Keep an eye out, and we'll see where we land on it all. I am now going to open up the floor to questions, and before I do, I'm just going to say that the contact details for Joe, Isabella and I are on this slide. You've also got QR codes, so if you're not already connected with us on LinkedIn, then please do feel free to scan that and connect with us. We all post regularly on LinkedIn. Joe, Isabella and I all have different specialisms in employment law. So my passion project is equal pay. Isabella's focusing on sex discrimination, and Joe's specialty is disability discrimination. So if any of those things are of interest, then our LinkedIn content is going to make your day, because that's what we post about pretty much all the time, as well as just kind of giving general updates on things like the Employment Rights Bill, which is the world we're living in now. So does anyone have any questions? I think, guys, we've been so good. We've explained everything so clearly that there are no questions.
If you do think of any, though, link up with us on LinkedIn and just drop us a message. If something
Definitely
springs to mind, you think, oh, I've got my Axe phone Christmas party tomorrow, what should I be doing in terms of X, Y, and Z? I also wanted to just add a little thought on the unfair dismissal part. So the median award for unfair dismissal, recent statistics have shown, is about £7,000. So removing this cap might not actually be that beneficial, unless, like Alex says, we have an age issue widely as well. I think, and I don't know, that was a compromise between the businesses and the trade unions to get rid of that day one right and say, actually, let's remove the cap as that reason. So it was just a point to say that particularly could be why, but we don't know. And we should also add and caveat, this is the law at the moment, and it will very likely change probably before Christmas.
Yeah, I mean, it's not even the law at the moment, is it? It's
No,
just
the proposals, yeah.
We don't know. And that's the world we're all living in the moment. It's great for employment lawyers, rubbish for everyone else. Okay. Well, I haven't seen any questions, so I guess all that's left for us to say is thank you all for joining us, and we'll circulate the slides after this session.
Oh, we've got a question there.
Oh, we had a last minute question. Sorry.
Let's go for Ross, HRBP, who's new to the role. Find these webinars so helpful. Really appreciate it. I'm really pleased. Are there other ways you recommend staying up to date? Yep. So we have a mailer. So we regularly send out content. We do articles every week. Like we said, you can also follow us on LinkedIn. We all very regularly post within our team. So absolutely, if you want us to reach out to you and we can help facilitate those things, we will do that.
Definitely. All right. Well, thank you very much, everyone. I think we'll call time.
Thank you all.
Thank you.